This is HOA neighbor court. I did not realize how organized they were. Cynthia Young was blocking my driveway with her fuchsia blazer and a measuring wheel when I pulled up that Tuesday afternoon. She was yelling before I even opened my car door. "You are trespassing on HOA common area," she said, "and if you do not move your vehicle immediately, I will have it towed and fined." I work in IT support. I had just wrapped a long shift, and I was staring at a fresh slab of concrete that definitely was not there 2 weeks ago when I left for a work trip. The parking pad they poured ran 6 feet onto my property line. "I am parked in my own driveway," I said. "That pad is on my land." She held up her phone and snapped a photo of my license plate. "We have procedures for a reason," she said. "This is common area, approved by the board, and you are in violation." The stakes for me were immediate. I needed that strip of my lot for access and safety. My side gate, my utilities easement, my fire lane clearance, all of it was now blocked by HOA asphalt. I live in Phoenix, in a gated neighborhood with confusing easements and shortcuts, called Willowbrook Estates HOA. I moved here because I wanted a quiet neighborhood and a fresh start. The gates, the rules, the tidy sidewalks, it all seemed like a good trade for a little structure. Cynthia Young is the HOA president, and she runs the board like a personal kingdom. She has a clipboard, a ring of keys to every common area shed, and a habit of showing up unannounced with that measuring wheel. The neighborhood has 3 cut-through alleys, 2 retention ponds, and a patchwork of old easements that nobody really understands. Most people just pay their dues and stay quiet. I had been doing the same until I came home and found part of my lot paved over. That Tuesday, Cynthia told me the contractor had assured her the project was approved and the boundaries were confirmed. When I said I never approved anything, she waved her clipboard and said the HOA owns the common areas, so owner approval was not required. I told her this was not common area. She said I would receive formal notice and walked back to her white SUV, measuring wheel clattering on the pavement behind her. I stood there in my seafoam green jacket, looking at the orange survey stakes someone had knocked over and the neat edge of asphalt that ran right across my property line. I took photos with my phone. I took measurements with a tape measure I keep in my trunk. Then I went inside and pulled my title documents. The title documents showed no easement on that corner. The parcel map was clean. My lot line ran exactly where I thought it did, and the new parking pad crossed it by 6 feet and 3 inches. I scanned everything and saved it to 3 different folders. Then I opened my email and found a message timestamped from 2 days earlier. It was from the HOA. Subject line: Notice of Common Area Improvement Project. The body was vague. It mentioned drainage and parking optimization and said the work was board approved. There was no site map, no parcel reference, no mention of my address. At the bottom it said, "If you have concerns, contact the board within 48 hours. I checked the send time again. The email arrived while I was in the middle of a work trip with no reliable signal. The 48-hour window had already closed. I replied immediately. I wrote that I had not received the notice in time, that the project encroached on my property, and that I needed the asphalt removed. I attached a photo of my title documents. I sent it at 9:47 that night. The next morning, I got an auto reply from the HOA management company saying my message had been forwarded to the board. By noon, I got a response from Cynthia. She said the board had reviewed my concerns and determined that the project was compliant with all covenants and recorded easements. She said I was in violation for obstructing access to common area and that I had 72 hours to cure or face a hearing. I read it twice. There was no acknowledgement of my title documents, no reference to the parcel map, nothing, just a threat. I called the surveyor who had done my closing inspection when I bought the house. His name was Martin. He remembered the lot. He said he could come out the next day and reconfirm the boundary with the county records. I said yes. Then I called a real estate attorney I had worked with before, left a voicemail, and waited. That afternoon, I went outside to check the stakes again and found Cynthia standing at the edge of my driveway with 2 other board members. One of them was holding a camera. She said they were conducting an inspection to document my obstruction of common area. I told her she was on my property and she needed to leave. She said the HOA has the right to inspect common areas and enforce covenants. I pulled out my phone and started recording. She held up her measuring wheel like a weapon and said, "We have procedures for a reason, and you are in violation." Then she turned and walked away, heels clicking on the asphalt. That evening, Martin the surveyor emailed me. He said he had pulled the county parcel map and cross-referenced the legal description on my deed. He confirmed the parking pad encroached by 6 feet and 3 inches. He said he could prepare a written report and testify if needed. I forwarded his email to the HOA and copied my attorney. My attorney finally called back. She said the HOA had no authority to build on my land, easement or not, and that I should document everything and request an emergency hearing to get it on record. She said if they refused to remove the asphalt, I could file for an injunction, but that would cost time and money. I told her I would try the hearing first. She said to be ready for them to play games with notice and deadlines. She was right. 2 days later, I got a certified letter. It was a notice of violation hearing, scheduled for the following Tuesday at 7:00 in the evening, at the clubhouse. The letter was dated 4 days earlier, but the postmark showed it had been sent only the day before. The letter said I was required to appear, and that failure to appear would result in automatic fines and a lien on my property. It also said I was prohibited from bringing legal counsel to the hearing. I called my attorney. She said that was probably unenforceable, but that showing up with a lawyer would escalate things and might backfire politically. She told me to go alone, bring all my evidence, and stay calm. I said I would. Then, I printed 3 copies of everything: my title documents, the parcel map, the surveyor email, the county GIS screenshot, and every email the HOA had sent me. The weekend before the hearing, a neighbor named Greg stopped me in the driveway. He lives 2 houses down. He said he heard I was fighting the HOA and that he wanted to give me a heads up. He said Cynthia had been emailing other owners, telling them I was blocking a safety project and putting the whole neighborhood at risk. He said one of the emails copied him by mistake, and he thought I should know. He forwarded it to me. The email said I was refusing to allow access to my property line for drainage improvements, and that the board might need to take legal action to protect the community. None of it was true. There was no drainage issue. The parking pad had nothing to do with safety. It was just Cynthia trying to build political cover. I thanked Greg and added the email to my folder. That same weekend, I got another email from the contractor who poured the pad. He said he had been contacted by the HOA management company and asked to confirm that the project boundaries were approved by engineering review. He said he was just following the plans the HOA gave him, and that he had been told the property line was further back. He attached a site diagram. The diagram showed my lot line in the wrong place, shifted 6 feet onto my property. It was labeled as an HOA common area easement. I had never seen that diagram before. I checked my title paperwork again. There was no recorded easement. I replied to the contractor and asked where he got the diagram. He said the HOA gave it to him and told him it was county approved. I forwarded the whole thread to my attorney. She said it looked like someone at the HOA had fabricated an easement to justify the encroachment. Monday night, I could not sleep. I had a major work deadline that week, a system migration I had been planning for 2 months, and the hearing was scheduled right in the middle of my testing window. I sat up reviewing my printed documents, highlighting key sections, rehearsing what I would say. I kept thinking about Cynthia and her measuring wheel, her clipboard, her fuchsia blazer, her voice saying, "We have procedures for a reason." I thought about the neighbors who would be at the hearing, the ones who got her emails, the ones who believed I was blocking a safety project. I thought about the board members who had stood in my driveway with cameras, documenting my so-called obstruction. I knew I had the evidence. I just did not know if it would matter. Tuesday evening, I drove to the neighborhood clubhouse. It sits near the main entrance, a low stucco building with a tile roof and a small parking lot. Cynthia's white SUV was already there, along with 4 other cars. I parked, grabbed my folder of documents, and walked in. The meeting room was set up with a long table at the front and rows of folding chairs facing it. Cynthia sat in the center of the table in her fuchsia blazer, flanked by 2 other board members. There were maybe a dozen residents in the chairs, including Greg. Cynthia did not look up when I entered. She was shuffling papers and whispering to the board member on her left. I sat in the front row. At exactly 700, she called the meeting to order. She said the board had received a complaint regarding obstruction of common area access, and that I had been given multiple opportunities to cure the violation. She said the purpose of the hearing was to allow me to present any evidence or explanation before the board imposed fines and a lien. She said I would have 10 minutes. I stood up. I said I was not obstructing anything, that the parking pad encroached on my property, and that I had documentation to prove it. She cut me off. She said the board had reviewed the project and determined it was compliant. She said if I had evidence, I should submit it in writing within 48 hours. I said I had it with me and I wanted to present it now. She sighed and said I could proceed, but to keep it brief. I walked to the front of the room. I had brought my laptop. I opened it and pulled up the county parcel map. I turned the screen toward the room. I said, "This is the official parcel map from the county assessor. My lot line is here." I pointed. The parking pad crosses it by 6 feet and 3 inches. This is not common area. This is my land. Cynthia leaned forward. She said the county map was not binding and that the HOA covenants governed common area boundaries. I said there is no covenant or easement on my title. I pulled out the printed title documents and held them up. I said, I have the deed, the legal description, and a surveyor report confirming the boundary. She said the board had its own engineering review. I asked to see it. She did not answer. Then I pulled out the email from the contractor. I said, the contractor told me the HOA gave him a site diagram that showed my lot line in the wrong place. He was told it was county approved. It was not. Someone fabricated an easement. Cynthia's face went red. She said that was a serious accusation and that I had no proof. I said I had the email and the diagram, and I was happy to share both. I handed the printed copies to the board members. They passed them down the table. Cynthia grabbed one and stared at it. She said the contractor must have been mistaken. I said he was told by the HOA management company that the boundary was approved. She said the management company does not make those decisions. I said then who does? She did not answer. One of the other board members, a man in a polo shirt, spoke up. He said he had not seen the contractor diagram before. He asked Cynthia if engineering had reviewed it. She said yes, but she could not locate the file at the moment. He asked when the review was done. She said before the project started. He asked for the date. She said she would have to check. He looked uncomfortable. Another board member, a woman with glasses, said she also had not seen any engineering review, and that she thought the project was just a repaving of existing common area. Cynthia said it was, and that my objections were based on a misunderstanding of the property line. If you want to see how this plays out, hit that like button and subscribe for more HOA nightmare stories. I said it was not a misunderstanding. I pulled out the county email I had received that morning. I had sent a formal inquiry to the county planning department, asking them to confirm the boundary and whether any easement was recorded. They replied with a one-line answer and a reference to the official parcel map. The email said, "No easement is recorded on parcel reference number, and the boundary is as shown on the attached assessor map." I had printed it. I handed copies to everyone at the table. Cynthia took hers and read it. Her hand was shaking. She said the county was not always up to date and that the HOA covenants superseded county records. The board member in the polo shirt said that was not how easements work. He said if there is no recorded easement, the HOA cannot claim common area on private property. Cynthia said the board had relied on professional advice. He asked from whom. She said the management company. He said the management company is not a licensed surveyor or attorney. The room was silent. Greg, sitting in the third row, raised his hand. Cynthia ignored him. He stood up anyway. He said he had received emails from Cynthia saying I was blocking a safety project, and he wanted to know what the safety issue was. Cynthia said drainage. Greg said the parking pad was uphill from the retention pond, and there was no drainage path. Cynthia said the board had reviewed it. Greg said he wanted to see the review. Cynthia said it was an executive session document. The board member in the polo shirt said he had never seen any drainage study. The woman with glasses said she had not either. Cynthia said they must have been copied on the email. They both said they were not. Cynthia stood up. She said the hearing was over and that the board would deliberate and issue a decision in writing. The board member in the polo shirt said he wanted to table the violation and schedule a proper review with a licensed surveyor. The woman with glasses said she agreed. Cynthia said that was not necessary. The polo shirt member said he was making a motion. The woman with glasses seconded it. Cynthia said the motion was out of order. The polo shirt member said it was not, and that Robert's rules allowed any board member to make a motion during a hearing. Cynthia sat down. She looked at me. She said, "This is not over." I said I had kept every photo and every email, and I was prepared to take it as far as necessary. She did not reply. The board voted. 2 in favor of tabling the violation, 1 opposed. Cynthia was the one opposed. The polo shirt member said the board would hire an independent surveyor to confirm the boundary, and that no fines or liens would be imposed until the survey was complete. He said the board would also review the contractor agreement and the site diagram to determine how the error occurred. Cynthia said she reserved the right to seek legal counsel. The polo shirt member said that was her prerogative, but the board had a fiduciary duty to the homeowners, and building on private property without consent was a liability. The meeting adjourned. I packed up my laptop and my folder. Greg walked over and shook my hand. He said, "You handled that perfectly." I said I just told the truth. He said that was more than most people do. Outside in the parking lot, Cynthia was standing by her white SUV, talking on her phone. I walked past her to my car. She ended the call and turned toward me. She said, "You think you won, but the HOA owns the common areas, and we will prove it." I said the county already proved it, and the board just voted to confirm it. She said the board made a mistake. I said the board followed the law. She said, "We have procedures for a reason." I said, "And I have title documents for a reason." She got in her SUV and drove off. I stood there in the desert evening air, my seafoam green jacket zipped up against the cooling breeze, and I felt the weight lift. It was not over, but the board was on record. The surveyor was coming, and Cynthia had been publicly corrected. 2 weeks later, the independent surveyor confirmed everything I had said. The parking pad encroached by 6 feet and 3 inches. There was no easement. The contractor diagram was wrong. The board held another meeting and voted to remove the portion of the pad that crossed my property line and to reimburse me for my surveyor costs. Cynthia abstained from the vote. She resigned as HOA president a month later, citing personal reasons. The new board president sent me a formal apology letter and said the HOA would be implementing new procedures for common area projects, including mandatory owner notification and third-party boundary review. I framed the letter and hung it in my garage, right next to the photo of the orange survey stake and the measuring wheel lying in the dirt. I still live in Willowbrook Estates. The neighborhood is quieter now. The new board is more careful. Cynthia moved to a different development across town. I see her sometimes at the grocery store. She does not make eye contact. I park in my driveway, right up to the property line, exactly where I am supposed to be. The asphalt ends cleanly now, 6 feet back from my lot. The survey stakes are gone, but I kept one in my toolbox, just in case. I learned that having the evidence is only half the battle. The other half is being willing to stand up and use it, even when the whole room is stacked against you. Thanks for watching, and I will catch you in the next one.